5 seconds to go. Start. In the said order, this court observed that the right to bail in cases of delay coupled with incarceration for a long period depending on the nature of the allegations should be read into section 439 CRPC and section 45 of the PMLA. The court held that the constitutional mandate is the higher law and it is the basic right of the person charged of an offence and not convicted that he be ensured and given a speedy trial. It further observed that when the trial is not proceeding for reasons not attributable to the accused, the court, unless there are good reasons, would be guided to exercise the power to grant bail. The court specifically observed that this would be true where the trial would take years. It could thus clearly be seen that this court, in the first round of litigation between the parties, has specifically observed that in cases of delay coupled with incarceration for a long period and depending on the nature of the allegations, the right to bail will have to be read into section 45 of PMLA. A division bench of this court in the case of Ram Kripal Meena versus Directorate of Enforcement was considering an application of the petitioner therein who was to receive a bribe of rupees 5 crore and from whom an amount of rupees 46 lakh was already recovered. In the said case, the petitioner was arrested on 26 January 2022 in connection with FIR number 402 of 2021 registered against him for the offences punishable under sections 406, 420, 120B of IPC and section 4 and 6 of the Rajasthan Public Examination Prevention of Unfair Means Act 1992. He was released on bail by this court by order dated 18th January 2023. Thereafter, the petitioner was arrested by the ED on 21st June 2023. The court observed thus, adverting to the prayer for grant of bail in the instant case, it is pointed out by learned counsel for ED that the complaint case is at the stage of framing of charges and 24 witnesses are proposed to be examined. The conclusion of proceedings thus will take some reasonable time. The petitioner has already been in custody for more than a year. Taking into consideration the period spent in custody and there being no likelihood of conclusion of trial within a short span, coupled with the fact that the petitioner is already on bail in the predicate offence and keeping in view the peculiar facts and circumstances of this case, it seems to us that the rigours of section 45 of the Act can be suitably relaxed to afford conditional liberty to the petitioner. Ordered accordingly. In the light of the specific observations of this court in paragraph 28 of the first order, we are not inclined to accept this submission. Stop.